Understanding parents' rights can be difficult. We'll look at some of the key points to help you be better able to support your child. You have the right to view any educational records related to your child's special education services. If you disagree with the school's evaluation results, you may request an evaluation from an outside organization. The school will choose whether to provide the evaluation or request a due process hearing to dispute your argument. If you provide documents from an outside evaluation, the school must consider the results. You must be provided understandable written notice of meetings to change or initiate evaluation, identification, placement, or FAPE a reasonable amount of time before the change. You should receive a copy of the parent's rights at least once a year. You may request a copy at any time. You should also be provided a copy when your child is initially referred for evaluation, you request a due process hearing, or your child is removed for disciplinary reasons. The school needs your consent to begin initial evaluation or reevaluation, begin initial services, or change services greater than 25% of the school day. You may either refuse to consent or withdraw already provided consent. You may also refuse part of the proposed services and consent to another part. Mediation may be used when there is a disagreement to discuss the conflict and find a solution. You can request a mediation. You do not have to agree to mediation. See the parents' rights document for contact information. A due process hearing is a legal way to resolve disputes. It is more formal than mediation. You or the school can request a due process hearing. The school district is responsible to pay for the hearing. See the parents' rights document for current contact information. There are additional rights during the due process hearing. You have the right to be accompanied by an attorney or other knowledgeable individual. Change of placement means that your child has been removed from the setting more than 10 days in a school year, or they have been placed in an interim setting for disciplinary reasons. Educational services do not have to be provided for under 10 days of removal, but do have to be provided by the district for more than 10 school days of removal. A manifestation determination review will look at the action and your child's disability to see if they are related. If the school district has provided a free appropriate public education for your child, they are typically not required to pay for a private education. In order to be reimbursed for private education, you must inform the IEP team you are rejecting their proposal and give written notice at least 10 business days before removing your child. A formal complaint investigation will determine if a school is following laws and regulations. You may request a formal complaint investigation along with a due process hearing. See the parents' rights document for up-to-date contact information. The school will assume both parents are eligible to review records unless they have been provided with documentation otherwise. You may request the school to change incorrect records. The school may not release your child's records without your consent to anyone not covered by FERPA. The school must protect your child's confidentiality and records. The school district must pay for any services provided by your child's IEP. You cannot be required to sign up for public insurance or be charged fees such as copays. Filing health insurance claims is voluntary and must have your consent. Information about who to contact is at the back of the parents' rights document.